Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us, coming to you from Washington's premier indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Now, earlier today, I slapped together, and I do mean slapped together, a video about a huge ruling that came out from the United States Supreme Court in the matter of NRA v. Vullo. It is a tremendous win, not only for the NRA, but for the American people in general, as it significantly preserves not only our Second Amendment rights, but just as equally important, our First Amendment rights. Then a couple hours after the ruling came out, apparently we got a verdict on 34 felonies in New York on former President Donald Trump, and that's going to absolutely suck all the air out of the room for the next couple days. So we're going to get this video shot today. We're going to sit on it and wait until the world's ready to come back to some other subjects. But this is a huge win. It's a huge win for many reasons. It's a unanimous win as well. So today, let's spend a few minutes and let's talk about the Supreme Court rules 9-0 in favor of the NRA. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by Right to Bear. That's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, America, this is what we're talking about. This is our more polished video. We've had a chance to sit down and geek out on the opinion that just came out today, the last day of May 2024, in the matter of National Rifle Association v. Vullo. What is that all about? Well, yes, it does involve the Second Amendment, but predominantly this is a First Amendment case. And this is why it's really important, America, because this deals with what happens when your local and state government decides to weaponize their authority against their political opponents. Not like that would ever happen until the year 2024 in the United States, right? Now, the background here, just to kind of cut to the chase, is that Governor Andrew Cuomo was very anti-gun and wanted to essentially do everything humanly possible to undermine the NRA and any other Second Amendment organization. Maria Vullo, who happened to be the superintendent of the New York State Department of Financial Services, was then given marching orders to basically go out to all the insurance companies out there that insured the NRA in any way, shape, or form, including Lloyd's of London. If you don't know much about insurance agencies, all you need to know is that Lloyd's of London is the insurance company that often insures the insurance companies, okay? They're big time. And if you don't have them supporting you, then the smaller independent insurance agencies can't happen. If you can't have insurance, well, you can't really do business. And that is exactly the intent that the state of New York had when Governor Cuomo turned Miss Vullo loose on the banking industry, all in the hopes of absolutely destroying the NRA and any other similar Second Amendment organization. The NRA, once they had the insurance rug pulled out from under them, turned around and sued Vullo in the state of New York in the United States District Court for the Northern District of New York. The state of New York and Vullo moved to dismiss the claim, saying, hey, listen, you can't even prove that there's even any First Amendment infringement going on here, and so therefore there is no claim. This case should be dismissed. The trial court was not persuaded at all. It said, no, they have in fact alleged a First Amendment claim, and this case needs to go forward. So Vullo and the state of New York took it up to the Second Circuit Court of Appeals, which shockingly, not so much, actually reversed the trial court and said, yeah, there is absolutely no First Amendment claim here whatsoever. This is a frivolous lawsuit, and they dismissed the suit. The NRA then appealed that decision to the United States Supreme Court, who granted review of it, and away we go. Now, let's remember that the state of New York's actions were so egregious that the ACLU joined the NRA as petitioners and amici on this particular issue. Let us also remember, when we go back and we look at this, that the state of New York's actions were so egregious that the opinion is authored by Justice Sotomayor, and the decision comes down as a 9-0 decision. That means every single justice believes the state of New York violated the NRA's First Amendment rights. So New York, put that in your pipe and smoke it. Now, I want everyone to pay careful attention to the rule of law that comes from this, because for people like us that live out here in Washington State with a highly politicized attorney general who will wield his power come hell or high water to inflict his will upon his political opponents, and we see this in many other states, this rule of law, well, it's going to come back and haunt some of them, because the Supreme Court today specifically stated a government official can share their views freely and criticize particular beliefs, and she can do forcefully in the hopes of persuading others to follow her lead. In doing so, she can rely on the merits and force her ideas, the strength of her convictions, and her ability to inspire others. What she cannot do, however, is use the power of the state to punish or suppress disfavored expression. Now, the old case law was a case way back from the 1960s called Bantam Books, and that's where both sides were trying to decipher is how much of that case was applicable to this set of facts here. Ultimately, what the Supreme Court has ruled, Bantam Books stands for the principle that a government official cannot do indirectly what she is barred from doing directly. A government official cannot coerce a private party to punish or suppress disfavored speech on her behalf. And as I mentioned, what the big beef here is had the NRA actually established a First Amendment claim? It's almost like what we see in the Second Amendment cases where you see the courts trying to give the government the out, like, well, have they actually established that the Second Amendment even covers this type of conduct? But the rule to proceed on a lawsuit in this fashion moving forward, according to the United States Supreme Court today, is to state a claim that the government violated the First Amendment through coercion of a third party. A plaintiff must plausibly allege conduct that, viewed in context, could be reasonably understood to convey a threat of adverse government action in order to punish or suppress the plaintiff's speech. Now, for all of you who have these hyper-politicized attorney generals, Washington, you know what I'm talking about, I want you to pay very careful attention to this warning that the United States Supreme Court gave in this opinion. In sum, the complaint, assessed as a whole, plausibly alleges that Vullo threatened to wield her power against those refusing to aid her campaign to punish the NRA's gun promotion advocacy. If true, that violates the First Amendment. Now, one of the arguments that the state of New York and Vullo had made is, hey, listen, this isn't really being done as official business. This is really being done through a lot of backroom channel communication. And candidly, we are always held accountable to the voter because they could vote us out. Of course, the voter needs to be aware of this nefarious activity to actually hold you accountable for it. And so what the Supreme Court pointed out, yet whereas here a government official makes coercive threats in a private meeting behind closed doors, the ballot box is an especially poor check on that official's authority. Ultimately, the critical takeaway is that the First Amendment prohibits government officials from wielding their power selectively to punish or suppress speech directly, or as alleged here, through private intermediaries. Okay, and then there is a couple of concurring opinions. Now, we had done a video that we never got around to publishing where we made some predictions on what was going to happen with the United States Supreme Court on several cases. The prediction we made on NRA v. Vullo was that the NRA was going to win 8-1. The one justice that we thought was going to dissent was Justice Brown Jackson. We based that upon her line of questioning in Garland, which candidly just proved that she didn't really understand anything that was going on. She did author a concurring opinion. It's a troubling concurring opinion because she basically believes that anytime government is acting in a coercive nature, that doesn't necessarily mean that they're suppressing First Amendment expression. I find that difficult to believe, but hey, you might want to take a look at it because it gives you an idea of the type of justice that she is likely to be. Bottom line is, this is a huge win for the Second Amendment, but it's a much, much larger win for the firearms industry as a whole and an incredibly huge win for the First Amendment. The case, once again, is National Rifle Association v. Vullo. We're going to link up the order of the court down below so you can geek out on it for yourself. If you got any ideas for videos that we should be doing here at Washington Gun Law, click on that link right there. Some of the best ideas we ever had weren't really our ideas. If you need to get a hold of Washington Gun Law because you have some questions about this or whatever else is left of our Second Amendment rights, you guys should know how to get a hold of us by now. If you don't, that information is down there in the description box. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.